those interrogations and the recordings. And as I say, all have now been provided to him. This response from the NDPP is in respect of the recordings that he says he subsequently learned were made during his interrogations, and he requires those recordings for purposes of this, I think he says it's the Johannesburg case.
My learned friend,
please,
she might not be finished at this point. I'd like to address you.
Please let her finish, please.
But I got the impression she was finished. That's why I said I would like to respond.
You came in mid-sentence, Ms. van den Heever, please.
Thank you, Chair. So that is so far as the witness sees, that's insofar as witness sees testimony is concerned. It's the two recordings, it's the recordings that were played through witness C in this forum. That deals with the issue at paragraph 5. Now, I must say, the YouTube clip referred to at paragraph 5, I haven't watched, so I'm not in a position to tell whether it is all these audio clips in succession or otherwise. So that insofar as witness C's testimony is concerned. The further question that the chair asked me is regarding paragraph 7, which references ongoing investigation. Now, that paragraph states that the portion not made publicly available at the Commission contains sensitive information relating to an ongoing investigation. It doesn't identify what investigation. It doesn't suggest the investigation is against Mr. Matlala. It could very well be investigations pertaining to other issues where he is not a suspect. I submit that it is not a basis simply because SAPS is investigating to then seek to invoke or to assert the right not to incriminate himself. It takes us back to paragraph 109 of the Concord judgment, which is when the question is posed, that is the point at which to determine whether there is a risk that the witness will incriminate himself. What any other interpretation would suggest, because there is an investigation involving inter alia, an interview that Mr. Matlala had with the members of the SAPS, then those issues cannot be traversed in this commission because there is an investigation. The letter doesn't even suggest that Mr. Matlala is under investigation for whatever it is that the NDPP suggests is subject to ongoing investigations.
Perhaps a difficulty I have, Ms. Silo, is not having an idea of where you are going, but where I'm sitting now, what you appear to be doing is the flip side of what Mr. Matlala was doing, and which I said he cannot do. Asking him, I'm again referring back to your very first question, and I'm not referring to what you say now in respect of the content of the letter. My sense from what you did right at the beginning about the recordings, plural and in general, does not focus on specifics in the sense that this recording says this, and here's my question about that, Mr. Matlala. What is your response?
Yes.
That is what I would prefer than asking a broad and generalized question about the recordings, if you see what I mean. That places Mr. Matlala in a difficult position, I think. So that is what I was trying to say. Maybe I did not convey it clearly when I said I have a practical suggestion, and that perhaps what you should do, Ms. Silo, is to ask specific questions relating to the recordings. That is what I had in mind, rather than these close to, the first one was indeed broad and generalized. Maybe your later question relating to the letter still comes very close to being broad to my mind. But as I say again, maybe that's because of where I'm sitting and not knowing where you are going. But I would prefer a situation where you say, there's this recording. this is what I want to raise with you about that specific recording. Here's the question, what is your response? I think we will make a good progress if we approach it that way. And we do that in the context of what we have already explained to Mr. Matlala yesterday. So he will not and should not give us yesterday's broad and generalized responses. May I plead with you to please
No,
do it
Chair,
that
it's
way?
not necessary.
I'm still going to give you an opportunity, Ms. van den Heever.
It's not necessary to plead with
Yes.
me. What I suspect perhaps
Yes.
happened, I was not as articulate as I would have hoped to be.
Yes.
The purpose of reading this letter
Yes.
was simply to deal with the concern that Mr. Matlala raised yesterday, wherein he suggested that those recordings involve investigations in which he's a suspect. It was at the broad level.
I think we are past that stage now.
Yes.
We are past that stage now, and Mr. Matlala sitting there, I even directly spoke to him about the legal position, and I think I remember him in so many words saying that he understood what I was conveying.
Then if he understood, it takes care of my issue, because yesterday, the bulk of the issue, I think, the engagement with Mr. Matlala was in regard to the criminal cases in which he's an accused.
Yeah.
Then he raised this issue of being a suspect because there are ongoing investigations. There is another matter in here for which I think Ms. Cordelia, I forget her surname, I apologize, has provided
An affidavit.
and those are investigations by IPID. So these are different investigations that I am referring to. And the point I seek to make to the witness is that you are not, contrary to the position you assumed, you are not under investigation currently.
I want to assure you that I will not allow Mr. Matlala to say nothing about those recordings because I'm being investigated. He will, in accordance with paragraph 109 of the Constitutional Court judgment, have to specify a crime for us to have a better idea as to the basis upon which the privilege is being asserted.
I'm happy to leave it at that on that basis, Chair.
Thank you very much,
Thank you.
Mr. Law. Ms. van den Heever?
Thank you, Chairperson. I promise to look and see and watch her light until it goes off, so as to not create the impression of trying to interrupt her, because that was not what I was doing. I got the impression she was finished. First of all, this letter was in response.
Do you still want to address this?
Yes,
Because
indeed.
I think now we've, after my engagement with Mr. Law, I think this is done and dusted.
No.
But let me hear you.
There's three issues I'd like to raise. First of all, this letter is in response to a very specific request, and the request related to the statement that was made by Mr. Matlala on his arrest. So it dealt specifically with the statement that was made in May of 2025. That statement we submitted, we entitled to under the provisions of Section 335 of the Criminal Procedure Act. So I want to make that clear. Maybe if my learned friend had the preceding letter, she would have understood.
May I ask to say something, please? I wonder if any of that matters now, because the upshot of my engagement with Mr. Law is that her engagement with Mr. Matlala on the basis of the content of that letter no longer arises. So addressing the letter, the background, the why, does not assist us much, except perhaps to delay the further progress of the hearing of the testimony itself.
Listen, there's a second issue that I'm going to ask your guidance for. I was not here yesterday, and I actually tried to see if the transcript was uploaded yesterday. What I've noticed, and what is patently clear from the answer or from the affidavit, the supplementary deposed to by Mr. Matlala, is that in addition to whatever is stated in paragraph 109, and I submit you need to read it together with the other paragraphs and in the specific contents of the AFTA judgment, the Mr. Matlala specifically seek to enforce constitutional rights that he says he's entitled to. Now, that issue seemingly has not been dealt with, and that's why I said, please forgive me if you did deal with it. I did speak to the juniors about that particular aspect. And the only question that I'm seeking clarification from you on at this point in time is if it is the Commission's stance that the only rights under the 1947 Act that Mr. Matlala can seek to enforce is the right against self-incrimination, that he has no constitutional rights before you, and that he cannot claim any of those constitutional rights at this point in time. As he set out in the affidavit, where he specifies those rights that he seeks to enforce. If I can please get your guidance on that aspect, Chairperson, because I think that the right, well, I don't even want to call it a right, what is stated in, I think it's section 3(4) of the 47 Act is extremely limited. We now have a constitution that goes far beyond that. And that is the rights that he seeks to enforce before you. Thank you, Chair.
Ms. Hassim? I'm directing myself to her because
Indeed, Chair.
she was to have argued these issues.
Chair.
Thank you.
Chair, first of all, I'm surprised that my learned friend is raising this now, because we've moved past it.
In fact, I wanted to say, but I just wanted to give you an opportunity. I wanted to say to Ms. van den Heever, raise your issue in relation to a specific question that has been put to Mr. Matlala, and let us see how the right you have, the constitutional right you have in mind arises. So it must be specific, and it must relate to a specific. That's how I wanted to, but...
I'm quite happy with your response, Chairperson. So I do understand that the client is entitled on each and every specific point to raise the constitutionality or the constitutional aspect that he says he lays claim to. Thank you, Chair.
Thank you.
Thank you, Chair. And that was a bit of a concern for me because I didn't know whether we're reopening the application that was brought, but I think it has since been resolved. So that is how I deal with that letter, and as I said, I will deal with the issues arising from the recordings in the manner suggested by the Chair. I have read the letter into record to state that there is nothing before us that informs the Commission that Mr. Matlala is a suspect in any ongoing investigations on matters arising from the recording. And I'll leave it there. We will come back to the recordings as in those portions as and when are necessary. Moving on then, Mr. Matlala, I would like to refer you to your supplementary statement at page 18. You recall yesterday when we engaged regarding your relationship with Mr. Hangwani Morgan Maumela and Mr. Suleiman Karim, you provided a joint response at page 18, paragraphs 93 and 94.
Yes.
You recall
Yes, I
that,
do.
yes. And we had a discussion about your paragraph 93, wherein you advised that your legal team was in the process of collating, it was subsequently corrected, documents that will prove that you are a suspect in matters relating to your relationship with either both or either one of the people identified there.
Yes, I do.
And to this end, there was a discussion around a quote-unquote SIU document, which if you heard the Chair, we resolved that it shall be made available to the document that is sought to be relied upon shall be made available to the Commission.
Okay.
You recall that. And I confirm it has since been made available. Commissioners, the document made available to us is now CJC 433. No, 443. Dyslexic moment there. In file 11. Now, what was made available to us as this quote-unquote SIU document appears to be the special tribunal, the SIU Special Tribunal order of the 29th of September 2025 by the Honorable Madam Justice Victor. It's an ex parte application for a specific order, and it's brought by the Special Investigating Unit and lists 78 respondents. My reading of this order is that it quotes as a second respondent MHR Maumela Family Trust. It cites as a third respondent Mr. Hangwani Morgan Maumela, NO, and then it cites him in his personal capacity as the eighth respondent. Do you confirm that you are not a respondent in this particular application?
Yes, I do.
And this order was basically a freezing order of certain properties registered either in Mr. Maumela's name or the family trust or other entities associated with him. And if we go to typed page 4 of that, that would be paginated 6. At paragraph 2, you'll see that this is an interim order. It says pending the final determination of the 41 separate civil proceedings to be instituted by the SIU, and then it issues the order. If we go to paragraph 2.1 overleaf, it appoints a curator bonus. And 2.2, it interdicts and restrains the specified respondents from alienating, selling, leasing, donating, transferring, or otherwise disposing of the vehicles. And 2.3, it orders the transfer of possession, custody, and control of the vehicles to the curator bonus. I see if we then go to paragraph 2.5 of the same order, at page 9, once again it specifies that the second, third, fourth, and fifth respondents are restrained from alienating or selling fixed property, immovable properties. Then it deals with the powers of the curator bonus. And at paragraph 2.13 of that order, that would be at your page 15. At the bottom, it reads, the implicated respondents and all of the other 39 entities and their respective directors, members, trustees mentioned in Annexure A, herein collectively referred to as the syndicate or the Maumela syndicate, are directed to make a full and frank written disclosure. Then it lists of movable, immovable, corporeal, incorporeal assets and all funds standing to their credit. And if we stay with that document and we try and find Annexure A, that Annexure A will be a document immediately at the end of that order. At page 20, and it's a list of 39 entities. And I see at item 36, the entity referenced is Black AK Trading Suppliers. And it lists the director as yourself. You confirm that, that's correct?
Yes, I confirm.
At 37, it's a company called Core Kabeng Trading and Suppliers, and once again lists you as the director. And at item 38, Falcon Car Trading and Suppliers, and once again lists you. Now, my reading of this document is reference to you or any companies you are associated with, what the court, I don't know where they got the phrase, but termed the Maumela syndicate, and from whom the court requires them to make a full and honest disclosure regarding funds standing to their credit, in respect of which the respondents of which you are not, or any of them, have a beneficial ownership. So there are specific declarations that the entities are required to make for purposes of this litigation. Was that the understanding that you also got?
No, it's not.
Okay, can you share your understanding with us and the basis thereof, please?
I was of the view that all these entities and their directors, they are under investigation.
Sorry, please say that again.
I'm saying I was of the view that all these entities and their directors are under investigation.
Which entities? The entities listed in Annexure A?
Yes.
And on what basis do you form that view?
That why would they want us to disclose our assets and our bank accounts or whatever is in our name if we are not under investigation?
But paragraph 2.13 tells you why the court is interested in those entities. It specifically says those entities must make full and frank disclosure under oath of all assets and all funds standing to their credit, in respect of which the respondents in this matter, or any of them, are the registered or common law owners, have a beneficial ownership, right, title, and interest, or some other type of real right therein, in terms identical to those set out in the draft disclosure affidavit. So the court tells you what the interest in those companies is. That cannot be interpreted to suggest that the companies themselves are under investigation by anybody, surely.
I hear you, Commissioner, but I think last time when you said you can extract information because this is not a code of law, even you can get information from newspaper articles or whatever. And I've been mentioning so many articles that have been from SIU and being investigated. So I do not know now because would it also apply to me that from that article that I got from the media or whatever, which I don't have now, which says that I'm under investigation, does it not apply to me?
Which article are you talking about, Mr. Matlala?
It's quite a lot. I can just Google now. I can.
No. In reference to the engagement we are having,
yes.
What article? Perhaps can you guide me?
I'm not in position of a cell phone now that I can just check one for you now. That
okay.
Anything that has to do with Tembisa Hospital, I'm under investigation.
Okay, so do I understand you correctly that because an article suggested you are under investigation, therefore you are under investigation and are not able to talk about the matters the article suggests you are being investigated for? Is that your take?
Yes, but I was not relying on an article. I'm saying this also proved that indeed I am under investigation, or else they wouldn't serve this to me. But beside this document, I'm referring to quite a number of articles that I know that the thing is I've never been approached by, I won't lie to you that I've been approached by an investigator saying that I'm under, I won't lie to you.
Okay.
Yes, I was never approached, but I just know that I am under investigation, which it might be true, it might not, I don't know that.
And precisely, I guess, because it might be true, it might not. Articles are known to claim a lot. You have just confirmed that you haven't been approached by any investigator. So it's not confirmed to you personally that you are under investigation.
Yes, but we are using the same articles to claim that I am under investigation. The same way as you yourself, you're saying you can use articles as evidence in this commission. So I'm using the same articles as well.
Isn't this issue resolved. Mr. Matlala says he has never been approached.
Indeed.
That he's under investigation. That puts the issue to rest, I guess.
I would think so, and I'd say I refer to this document because it was introduced by you
Of course, yes.
to avoid responding to the question relating to Mr. Maumela and Mr. Kasim. Kasim, yes. Karim Suleiman, my apologies. It's been a long week already. I apologize. I'll try that again. You introduced this document in dealing with your failure to deal with your relationship with Mr. Maumela and Mr. Suleiman Karim. And you suggested in paragraph 93 that those documents will demonstrate that you are a suspect. This document will demonstrate that you are a suspect. So we have considered it, and I'm putting to you that this document has got no bearing on you as a suspect and does not suggest that you are a suspect in anything.
Okay, Commissioner, so we're saying I'm not a suspect.
No, I'm saying this document, contrary to what you suggested, does not suggest you are a suspect.
I take it.
Okay.
So I just want to understand that does this mean that I'm not a suspect in any of the SIU?
I don't know. I don't know.
Exactly.
Yes.
So I do not want to engage in something that I do not know also.
No. What we are dealing with is a firm claim you made at 93, and I'm saying the document you put forward does not support that. Having done that, I'm going to invite you to then, as the Regulation 10.6 notice required of you, to speak of your relationship with Mr. Maumela on the one hand, Mr. Karim on the other hand, or collect both, if that is how it is.
Even though I might be a suspect.
In what?
Matlala, you've accepted that you haven't been interviewed or told that you're a suspect in arising from these documents that you were relying on. You may well be a suspect in other matters, but right now the discussion is you answered at paragraph 93 that there are documents from which it appears or it will show that you are a suspect. You've just accepted to Ms. Sillo that on this document at least, the one that you were relying on, you are not a suspect, but also you've not been approached by anyone that in law enforcement it has to be that told you that you are a suspect in these matters. I think it is fair that you should be then now required to answer now that we have established on the document that you relied on that you are in fact not a suspect, that questions that come from or relating to the 10.6 should be answered about your relationship with Mr. Maumela and Mr. Karim.
Before you leave Annexure A, Ms. Matlala, when you were first here, the Commission asked you about companies that you own or have interest in, and you only mentioned 3. But now in item 37 and 38 of Annexure A, there are 2 other companies that you did not mention. And I had this engagement with you. You mentioned Medicare 2024. You mentioned CAT VIP, the security company. And then you mentioned Black AK Trading Supplies. You did not, in your engagement with me, mention Core Kabeng and Falcon Car Trading. Why is that? Do you have interest in these companies, and why did you not mention them when I first asked you to clarify this issue?
Because those companies are deregistered.
They are deregistered?
Yes.
When were they deregistered?
Long time ago. I don't remember when, long time ago.
Because this judgment or this order of the tribunal is dated 25 September 2025, and it suggests to me that they still existed in September 2025.
Yeah, but with a quick search, we can verify that these companies are being registered, Commissioner.
All right. Thank you.
May I, Mr. Matlala, with regard to the point that your entities are listed in Annexure A, you are therefore being investigated. May I ask to take you to page 16 the same, the paragraph 2.13 of the tribunal's order. The tribunal's order.
Yes.
You still have it close by.
From 2.13, right?
Yeah.
Yes.
Perhaps instead of going
It's page 15.
yeah, let's start at page 15.
Yes.
The implicated respondents and all of the other 39 entities and their respective directors, members, trustees mentioned in Annexure A are directed to make a full and frank written disclosure under oath of all the property and or assets and of all funds standing to their credit. Now, here's what I want to engage you on. In respect of which the implicated respondents, so even though Annexure A may go beyond entities owned only by the respondents, and it includes, for example, your entities, but the part that I'm emphasizing says, in respect of which the implicated respondents, of which you are not one, or any of them, still the respondents, are the registered or common law owners, have beneficial ownership, right, title, and interest, or some other type of real right therein. So the contemplated ownership, beneficial ownership, right, title, or interest may be in your entities, for example. That is how I read this. And it does not translate to you being investigated. So it's still about the respondents. The focus is only on what interest they may have in other people's entities. Do you see what I mean? This is just to reinforce the point made by Commissioner Baloyi, which is that nothing here suggests that you yourself are being investigated. Would you agree with it?
I agree.
Thank you.
Thank you, Chair. Then, having disposed of that, let's turn back to our paragraph 93 of your supplementary statement, and we do so with reference to the Regulation 10.6 notice issued. The Regulation 10.6 is the first document in your main statement file. And you recall that, as we did with General Sibia, you were required to explain your history and your relationship, direct or indirect, with certain persons, and they included Mr. Maumela and Mr. Karim. So can we then, in the context of 2.2, deal with your relationship with Mr. Maumela?
Chairperson, sorry to interrupt. I'm wondering if yourself and my learned friend has taken into account the provisions of Section 332 of the Criminal Procedure Act, which deals with one being an accused person or a suspect by virtue of your company or the entity of which you are a director, and in relation to your directorship in respect thereof too. So that, by virtue of that fact, you are also, and you can also, and he's also vis-a-vis this particular order, based on what he said, a suspect in that particular matter.
No, I don't agree with that, Ms. van den Heever. I do not agree with it. This concerns property interests, beneficial interests of the respondents. And the point is that those respondents may have interests in entities owned by other people. So the order relates only to their interests in those other entities that are not theirs. That's all it is about. I've not read what this is about, but I'll just assume perhaps that it was about the seizures that usually emanate from that entity, the tribunal. So it makes sense that the tribunal would be interested in, fine, we got hold of these Lamborghinis and this and that, but what other properties do you own? Do you own any beneficial interest in other people's companies. The focus of the tribunal will only be on what the respondents own. And that they may own that in someone else's entity does not make that entity a respondent or subject to investigation. There's a leap in logic in suggesting just because I want to know whether Ms. van den Heever has a beneficial interest in Commissioner Baloyi's company, then Commissioner Baloyi's company becomes involved in whatever it is they require information from you about. I do not understand that logic.
Chairperson, maybe I've had the benefit of reading through the actual application and the affidavits that was, because I went to the trouble after we were here to get those. Maybe if I can suggest, I see it's almost 10 o'clock.
But in any event,
I can,
yes.
Because it refers specifically in the order to the set affidavit that relates to the issues of the Maumela syndicate that is discussed there. As I said, I don't want to place facts before you without just going to refresh my memory again on that. That's why I'm asking, maybe it would be convenient.
In any event, what should cut across all this, Ms. van den Heever, is to avoid us debating issues in general. If there is a specific crime with regard to this, in respect of which Mr. Matlala is asserting the privilege, let that be specific, please, in the interest of time.
And
otherwise, the day will go by without us covering any meaningful ground.
And that's exactly what I'm going to endeavor to do for you during the tea adjournment, to make sure that that is brought to the attention. The client, as chairperson knows, is a layperson. He doesn't know the niceties of the law when it comes to these issues. So please afford me the opportunity to pull those up and have a discussion with the client.
But whatever you pull up, bear in mind, because a lot may be said, affidavits in proceedings may go far and wide. Bear in mind that what I have referred to in this order, the tribunal's order, shows in so many ways that this is not about Mr. Matlala's entity. It's about someone else owning something in Mr. Matlala's entity. Bear that in mind. So whatever affidavit or whatever you'll come back to us about should not change that, I would imagine. Thank you very much.
Ms. van den Heever, I think the other thing, whatever you are planning to do during an adjournment, is to remember that Mr. Matlala has filed an affidavit in which he has set out why the defenses and the facts, supposedly, that he relies on for claiming the privilege, that is done and dusted. You don't get another chance from the bar to say there's that other document or that other fact that we didn't put before you. We took a break to allow you to bring an application in which you were going to plead facts on which you rely for Mr. Matlala to support Mr. Matlala to support his claim for the immunity or for privilege that he's seeking. You don't get to do that by going now as counsel to go and pull up other documents and then put them from the bar. He had plenty of opportunity and we are past that. We did that yesterday. We have read your affidavit. There's been an answer and a full answer to that. Submissions were made about it yesterday. We are past that, and I think you know that. I expect that you know that he had the opportunity in the affidavit and he made his best case in the affidavit, including in that paragraph 93. You don't get to have a second bite at the cherry from the bar. You don't.
I hear what you say, Commissioner. We will deal with that issue when we return. Thank you.
Thank you.
Thank you, Commissioners. So then this is where we lend Mr. Matlala. The document you put up yesterday, which is this SIU order, does not in any manner suggest that you are a suspect as you sought to testify and that therefore there is no right for you to assert in relation to a relationship you have with Mr. Maumela and or Mr. Karim or both. So I will then invite you, let's deal with Mr. Maumela. Please provide details of the relationship you have with him, the nature of the relationship, when it commenced, and then we take it from there. Thank you.
Thank you, Commissioner. I want to ask you first the question, if you will allow me. Just because I failed to prove, which I take it, what the chairperson said, that it does not prove that I'm a suspect, and I take it. I failed to prove that. So does it mean that entirely I am not a suspect just because I failed to prove that I'm a suspect, or I might be a suspect? I'm saying this because I do not want to waste the Commission's time. So I would prefer that if we do, I'll continue to comment about Maumela's my relationship with him. However, I want to understand that whatever that I think is under investigation, do you still expect me to comment on that? Because I couldn't prove that I'm a suspect, though I know from what I heard from different sources that I'm a suspect.
Mr. Matlala, as I understand the position, you sought to demonstrate that you are a suspect by producing the document that Ms. Sildo took you through, and including us for that matter. We have also demonstrated, and you now accept.
Yes, I do.
That document does not show that you are a suspect. You are not barred. This commission is not barring you from demonstrating that for C, D, and E reasons, I am actually a suspect, and based on that, I'm claiming my right to privilege. So do not understand what we engage you on just now. Do not understand it to mean that we say you are forever and ever not a suspect with regard to these issues, the issues under discussion now. We are not. But we are saying what you produced as proof of you being a suspect does not bear your claim out. Do you follow? I hope that answers you.
That I take and understand.
Thank you.
Yes.
Thank you. Thank you.
Thank you, Chair. With that understanding then, Mr. Matlala, can we start discussing your relationship with Mr. Maumela? Like I said, it would assist if you began it when, you started with when that relationship began, and you define or you describe that relationship up to date. Thank you. Then we'll take it from there.
Yes, I will. I think that I first met Mr. Maumela, I think I would be around 2015, 2016, somewhere around there. 2015, 2016, somewhere around there.
Thanks.
And my relationship with him, it was because both we have passion for sports cars. So there is this restaurant that we both we used to frequent in that restaurant somewhere in Sandton. So we used to meet each other there, and then because I like this car, and then that's when we started our relationship, because of the love of cars.
So would it be fair then to conclude that you are friends with Mr. Maumela and you share a passion for sports cars?
I conclude that, yes.
Do you have any other relationship with him, including business relationship or any relationship that leads to any one of you benefiting financially?
Yes, we do.
Can you tell us about that?
We were, both of us, we were in the, I wouldn't say it's a tender, but it was, what is it called? Not a tender, but let's just say, for the lack of a better word, I'll say a tender, but it's not. Like when you get the RFQs, it's not a tender, it's something else. I don't know what they call it.
Well, call it an RFQ.
Okay.
Okay.
Yeah. So, yes, we used to do that together.
What?
Like a joint venture or something? In what form do you do it together?
Like, if I get an RFQ and then we'll have money, then we'll take that money and purchase. Maybe the RFQ was in my entity. Then we'll take that money that we put aside and buy the whatever is needed, and then we'll take the money back and then, including profit, put it aside and then share the profits.
I don't know if you were talking about an RFQ, because then if you talk about investing money and sharing profits, it would suggest that we are beyond the RFQ stage. I understand an RFQ being a request for quotation.
Yes.
And this is where an entity submits a quotation in response to a public invitation, and then the quotation is successful or not successful.
Yes.
So in that process, until a determination is made, there are no profits to share as such.
Of course, yes.
So the RFQ does not provide.
Yes.
It's only if the quotation is accepted and then the award is made and the job executed that we can start talking profits.
Of course.
Okay. So now you say that the relationship you had with Mr. Maumela is that you would both invest and then share profits, and you say that with regard to an RFQ, having accepted then what is my understanding of an RFQ, would it be fair to say that following the submission of RFQs, you have been awarded certain public work from which you derived a profit?
Can you please repeat that question?
You indicated that both of you would invest and then derive profits. And you said so with reference to an RFQ. Now since you and I agreed what an RFQ is, just a request for quotation, which may be accepted or rejected by the entity. We have reached that point, right? We agree. So now I ask, is there any RFQ that was accepted on the basis of which you provided the work that was required or the goods that were required, from which you derived a profit that you shared?
Of course there was.
Which ones are those? Can you start listing them, please?
I can't. It's a plenty. I can't.
Okay, now which
Not
is...
that I don't want to. I'm saying is medical equipment, and then I do not. I would say a stethoscope, as for example, maybe quantity of the stethoscope, a different medical equipment.
Okay, let's do it differently. Let's talk about the entities that issued the RFQs. Which entities are those that you responded to and were successful?
I wouldn't know about his entities. I will only refer to my entities.
No, sorry, by entities, I mean, who issued the RFQ that you were successful in?
No, he will do it on his own, and I'll also do it on my own.
Mr. Matlala, the government entities that invited.
Or the government entity.
The government entities that invited.
I'm sorry, yes, yeah, I understand, yeah. It's a Department of Health.
Okay, now is that the National Department of Health or Provincial Department of Health? If it is the latter, which provinces?
Gauteng.
So it's just the Gauteng Department of Health?
Yes, I think so.
Nothing national.
I'm not sure what I did national. I'm talking about what I know. I don't know.
I'm interested in when you remember we're discussing your joint efforts here.
No, myself, I don't know anything about national.
Okay, so Then in respect of the Department of Health, what did those RFQs require? If you could just, whatever you can recall.
Medical consumables?
Yes.
Yes, that's it.
Okay. Now, when was the first RFQ? I'll take it that is an estimation on your part. Then when was the last?
I was not keeping, I don't know, let's say 2019, 2018.
2018, 2019.
2018, maybe.
Okay. Now, were there so many that you can't even recall whether there were 2, 3, 15, 25?
Yeah, there was quite a lot.
Where you were successful? I'm interested in the ones you were successful, not the efforts you made.
No, mine collectively for, I'll say, for 3 years, they were under 5 million rands. So it's not a lot.
That's you quoting alone?
Yes.
I'm interested in you and Mr. Maumela.
No,
remember,
we are not, I think maybe I've explained this wrong. We are
Okay.
not in a joint, there is a money that is somewhere there. So whatever you get is yours, whatever I get is mine. And then from that money that you borrowed, that's where you will, depending on how much you borrowed from that money. I'm not saying his companies I was benefiting from them or my companies he was benefiting from them.
Okay, let's...
The common thing that that because you said, was there any business that I did with him?
Yes.
I said, yeah, it's the money, but he will do his own thing and I'll also do mine on the side.
Okay, let's try it from this angle. Perhaps I asked whether you were involved in any business or business ventures. You said it's the money. Can you describe that, the nature of that business, of the money?
I think I just need to give you an example that I will say to you that just put 1 million and then I'll also bring 1 million.
Yes.
And then if you get your RFQs, you can take from that 1 million, depending on how much they want. You'll take 300,000. And on that, let's say you take 300,000, you go and buy whatever is needed for that from our money. And from that 300,000, and then when you bring it back, because of you've used the money, so it must come back with profit.
Okay, so do you create a pot of money where you both invest and from which you draw to individually respond to RFQs, or how exactly? I'm trying to understand how these transactions were happening, and please excuse me if I'm slow.
Commissioner, now we're going deep to the investigation that I was trying to avoid, but which I do not know whether I will be part of or not. So, however, for you to understand much better, I will say it's not like we've opened a mutual company and then have money in the bank for that specific purpose of this business. I will take it from, it will be money that maybe is depending on, it will be either in his account or mine. There was
you pooled, as in POOLED, you pooled funds together.
Yes.
And from those funds, if you got a contract, or if he got a contract, each one of you would then take money from the funds that you've pooled together for what's required at the initial stage of performing in terms of the contract you got. So you use a portion from those funds for that purpose.
Of course, yes.
Yeah. And then you say you then pay those funds back into the joint fund, if I may call it that. You pay that back. But you say you would have to pay it back with a profit, as I understand you. And don't nod, please.
No, sorry, I'm sorry. Yes.
Oh, yeah. And how would the profit be worked out?
10% of whatever.
10% of what you took from the fund, or
Yes.
10% of
Yes,
what
of
you would get from the contract?
What you took from the funds, yes.
What you took from the fund.
Which then would lead me to the question, does that become a revolving fund, or is the fund dissolved at some point and you split profits that have been earned by quote unquote the fund? How exactly does it work?
I will, okay, I'm going to give an example again. I will say,
Yes.
maybe you are the supplier.
Yes.
We need to buy stock from your company. So we'll put money in your company, and then whatever we want to buy, we already have credit. So we'll take from stock from your company, and then you will tell us how much is left there. Then anyway, both of us will know how much is left, and then we'll keep on adding money to that account.
It's not exactly what the answer you gave the chair, because you explained that.
The profits will get them, yes.
Yes.
No, the profit won't go back to you because you are not part of the business.
How do you split them when you are jointly contributing to the pool?
I made an example earlier that, I'll give an example that I've put 1 million into your account, which you are the supplier.
But in the example you make, I am not Mr. Maumela.
Not Mr. Maumela. You are not a supplier, meaning we buy stock from your company.
Yes.
Yes.
From the pool of funds that you and Mr. Maumela have raised.
Yes, but the money is in your account because you are the one who's supplying us with medical equipment. It's easy.
I'll never get it.
Ms. Matlala, you keep going back to, remember in your engagement with Chair, you said whatever profit you make,
Yes.
you must put the money you took out of the seed account.
Of course,
you must
of course.
take it back, and then with 10%, because the interest you earned is 10%, you put it back into this account.
Yes.
From which both
Yes.
of you can draw. Now, the question Advocate Silva is asking you is that account where you put the money back with 10%, at some point do you dissolve it, or what do you do with it? Not what you pay to the suppliers that supply you with the equipment. The account from which you draw and you pay back money once you've made profit with the 10%. What do you do with that account? Do you dissolve it and share 50-50 whatever is remaining, or what happens with it?
Yeah, that's where the confusion is.
Yes.
The money is not in the account. The money is, we approach you, like I was trying to explain to Advocate Sillo, the commissioner, I'm sorry, that we will approach you, and since you are the supplier who will supply us with medical equipment, that listen, buy the stock for us, and then the money will be in your account. So you know how much, you will know how much, we will know how much we have in your account. So let's say we have 1 million rands, and then I want a stock that is worth 300,000. So
What happens with the profit? I'm not concerned with what you have put in the supplier's account. Yes.
Yes, the profit, that's where I'm saying the profit comes back to us, not to the supplier.
I thought I understood earlier that you said there's money pulled into an account. Now, from how you're explaining, that's not the case. And I want to use a practical example. Hospital A wants still water, and they send out an RFQ, and you are interested to submit an RFQ. Can you just explain where does the money come from to buy from a supplier? Assume it's supplier X that has water. Just explain what you're telling us. Where does the money that gets paid to the supplier, where does it come from? And once you have supplied, of course at a premium, So you've got a profit. Where does that go? How do you handle that? So start with, where does the money to pay the supplier for 6 bottles of water come from?
Okay, Commissioner, let me do this. Let me start from the beginning, and then just please stop me where you don't understand so that we can have progress. We want to supply, me and Mr. Maumela, we want to supply medical consumables to the Department of Health. And we approach someone who's selling medical consumables. That person, we tell him that we will put upfront. I'll give an example of 1 million rands. It's just an example. I say it's an example. In his account. Should I get the RFQ first? Should I get the RFQ first? I'll go to that supplier and tell him, can I please give me stock that is worth 200,000? And he will give it to me. And because I took 200,000...
From where? Where do you take that 200,000 from?
The money is with the supplier, the person who's supplying medical consumables.
Where do they get it from?
Myself, and I said from the beginning that we will take 1 million, myself and Mr. Maumela, put it in the account of the medical supplier, the person who supplies medical consumables.
So from both your separate accounts?
Yes.
Each, or you or him, puts R1 million to the supplier?
Yes.
And then? And then the supplier, then you win, you get appointed. The supplier gives you the equipment.
Yes.
Right?
Yes.
And then the hospital, what happens with that medical equipment and the money?
I give an example that, let's say he gave me stock that is worth 200,000. And then when the hospital pays me back that, pays me the money, I have to take back that, the money that I borrowed, which is 200,000.
Mr. Matlala.
You borrowed it from whom? I think
it's not borrowed, it's my money, of course.
Yes, I think that's what we are trying to understand, that we all understand, Mr. Matlala, that you must pay the supplier. We accept that. Take it, we understand that part. What is confusing, at least for me, is when you pay the supplier, there are 200,000.
Yes.
That money comes from your bank account or Mr. Maumela's bank account.
Yes.
That's what you're saying, right? So you get that. And then you supply it to the hospital. Let's say it's a hospital. You supply it to a hospital. And it's 300,000 now when you supply to the hospital. You bought for 200 and the hospital pays you 300.
Yes.
You now have 100 rand profit or 100,000 rand profit.
Yes.
How does that get dealt with? It comes into your personal account?
Of course, yes.
And then what happens?
And then Mr. Maumela will get 10% of that profit.
Okay. All right.
I'm going to suggest this, Mr. Matlala. I think you are doing this deliberately. Less than 2 years ago, you won a 360 million contract from SAPS. And that, you can't have executed that contract with this understanding where we struggle to understand from you about money and transactions and suppliers, and it cannot be. You are doing this deliberately so that we go round and round in circles. Yes, you are.
No, I'm not. Okay, can you please explain to me what part is it that you don't understand?
Where you suggest that you and Mr. Maumela put money in a supplier's account and you buy for 200, why are you putting 2 million in that account when you are buying for 200?
But Commissioner, it's not a once-off thing. Remember, we are going to get stock from you now and then. So just in case it happens that at some point I don't have money, but I know that I've got credit in your company. So
you invest in a supplier's account up to 2 million, but your RFQ that you won is for 200,000. So the supplier holds that 800,000 until you get the next RFQ.
Yes,
Is that your business model?
yes.
Okay. So when you get the 10% that you said you called the chair, you said that 10% goes to the supplier's account.
I didn't say that.
Okay, where does it go to?
To the 10%, it will go, will share the profit. I said that.
Where does it go to?
To myself and Mr. Maumela.
So how does it get there? Because as Commissioner Baloyi pointed out to you, that 200,000 worth of medical equipment you provide to a hospital or to hospitals, for which the Department of Health will pay you.
I'm talking about profit here. Profit.
You must be paid before you can make a profit. Surely.
Yes, I'm saying the profit, that is the money that goes to my account, the profit. I do not know what part maybe you're missing from me. I don't understand.
I'm just a mere lawyer. Maybe these business issues are above my pay grade. Chair, I see it's 2 minutes to 11. This might perhaps be the appropriate opportunity.
Let's adjourn and resume at 11:30.